Kimon?
You're live.
Okay, we're live. Hello, good afternoon, everyone. Thanks for joining us for another awesome event that's presented by the Jamaica Diaspora Legal Support and Immigration Task Force. Today, we have another very informative session with one of our wonderful attorneys she's not on the task force, but she was kind enough to offer of herself for our event today, which will be focused on wills and trusts along with other issues in Jamaica. So a little about our presenter, Karisha Mckenzie. She is a partner of the Murray and Tucker law firm that is located in Falmouth, but they have different locations throughout Jamaica. And she practices in the areas of criminal, civil litigation, estates, conveyance, and special interest employment and industrial relations. Karisha, thank you so much for being here. And I'm excited, along with all the listeners, to hear what you will be presenting. Thank you so much.
Thank you very much, Michelle, for having me join this wonderful platform. It is certainly a pleasure. This afternoon, I will speak on a very important and relevant topic, that of estate planning and wills. Now, one thing that is sure in life, and everybody will agree that is death. And so it is very important that we plan for what will happen to our estate after we pass. Now, estate planning is the organizing of one's estate, right, to minimize incidents of taxes during lifetime and after your passing, right? It involves making provisions to ensure that your estate passes easier to your beneficiaries. Now, there are a number of ways that one can plan their estate, and I will be talking of 4 ways, but I'll be making I'll go into the will, which is one of those 4 ways, a little more than the others. Now, one of the ways that you could plan your estate is by making outright gifts of your assets. And this entails, for example, you may have a property that after you pass on, you may wish to leave to your children. Now, rather than to make a will, leaving it to your children after you pass, what you can do is to actually add the children during your lifetime. And what that usually involves is some transfer documents being signed by the person who is giving the gift and the persons who are accepting the gifts. And transfer tax is also payable on this gift. So for some persons may wish to use this avenue rather than to leave a will that will have to be probated after they pass on. There are, however, considerations that you must give, careful considerations, because once you have gifted somebody something, it is permanent. You can only get it back if they're willing to give you back, and they may not be willing to do so. So for example, if you place someone on your title, right, you have to ensure that you really want that person to be on the title. You can't just put them on it as security, because once the ink is dry, they're owners and there is no way really of you getting back So you can't change your mind later down the road and say, I don't want to bother gifting this person this property, I want it back. You won't get it back. So that's the drawback with the transfer of gifts in your lifetime. It is permanent, it is irrevocable. Also, one has to be careful of who they're adding to their titles. So you may have a minor child, and since when you pass on, you'd want your minor child to become the owner of your property. You may put the child on the title during your lifetime. It is important that one recognizes that when you put minors on a title, there are things that will flow from there, such as a caveat will be lodged by the registrar, and a caveat is something that once it is lodged, then if you want to do something with that title, suppose you want to sell it during your lifetime, the caveat will not allow you to do so without the registrar of titles giving their permission for you to do so. So you have to be very careful when you are adding a minor to your title. So that is transfer during a lifetime, transfer by gift. That is one way of planning your estate. The second way in which I will mention is that of a trust. Now, a trust is a relationship which arises whenever a person who is called a trustee holds a property, for example, for the benefit of some other person. And this they too, the trustee can also be a beneficiary of the trust. And really, anybody can be a trustee, but obviously you would want to have somebody who you can trust. So maybe a family member or a loyal friend. A stranger can be a trustee, but again, you won't know much of a stranger to be able to advise yourself whether that is advisable. Thirdly, joint ownership, right? So, and when I speak to joint ownership, I'm talking about, it could relate to bank accounts, to land ownership, personal assets such as a vehicle. Now, how this is used as an estate planning mechanism is that, again, suppose it is that you want your children to inherit, for example, your property, right? And you do not want to come off the title. What you can do is add your children to the title, and you can add them as joint tenants. And once you add them as joint tenants, then once you pass on, the children will automatically be the owners of the property. All they really have to do, so they won't have to probate any will, all they will have to do is to note your death on the title, and it's a simple process by way of which you pay death duties and send the relevant documentation that an attorney can compile to the titles office. And the same applies for bank accounts. If you add somebody as a joint owner of a bank account, you don't have to leave a will then in relation to that bank account. But once you pass on, the joint owner will automatically be the holder of the funds in the account. Now, fourthly, a will. And I will spend a little bit more time on a will, right? Because it is the most popular means of estate planning. Now, nowadays, it is very crucial that persons make their will. It used to be that one thought that it's only older persons that make a will. But in this day and age, it is important. I mean, young people are gaining more assets earlier than they would normally do. And so once you start to have assets, it's important that you start, because none of us knows when where we will go, right? So once we start to have assets, it's important that we kind of put something down in writing that will stipulate what is to happen to those assets should you pass on. So a will is an expression, right, by a person of their wishes once they have passed. So it's a legal document that one can actually do a will on their own. Here in Jamaica, the bookstores, for example, sells will forms, right, that you can actually write up on your own and have witnessed. Others may decide to go to an attorney who will draft and type up your instructions and then have you sign it thereafter, right? So what a will states is what is to happen to your estate once you pass. Now your estate is whatever assets you are leaving behind. So it could be property, motor vehicles, accounts, insurances, etc. Whatever assets you leave behind will form your estate. Now, it is important that you make a will, because only then will you get to say what will happen to your estate when you pass. It is also important that you make a will to capture what forms your estate, what assets you have, because there may be situations where you may be a little secretive, and so nobody really know the full sum of the assets that you have. And so when you have a will, you can state what you have and then indicate who those assets are to go to. Now, as indicated, you can go to a bookstore here or type it up on your own, your instructions as it relates to, you can type up your will. But there are certain formalities that has to occur for a will to be valid. So it must be in writing. I have to say that. I mean, you'll probably think that that goes without saying, but it really does not. I have persons who would come to me and said, you know, grandfather had said I was to get so and so when he passed on. It cannot be a will. So it has to be in writing. The will has to be signed by the testator. The testator is the person who is making the will. It needs to be witnessed by two persons, right? And those two persons must be present at the same time where the testator is to witness the will, right? So it can't be that as a testator, I sign here and I bring it, and a witness is here who put on their signature, and then tomorrow I bring it to somewhere else for the second witness to sign. It cannot work that way. Both witnesses have to be present at the same time. Now, these witnesses need not know what is in your will. So they're not reading your will to see what is there. All they're doing is witnessing your signature. And they themselves will affix their name and occupation and address to the will. Now, those information will become important in terms of the information of the witnesses, because once the will is being probated, after the testator passes, then at least one of the witnesses will have to do a document when the will is being probated. So it's important that the witness puts their name and their occupation and their address, importantly. Note that a beneficiary, and a beneficiary is anybody who you're giving anything under your will. They will be your beneficiaries of the will. a beneficiary cannot witness the will. All right? So if you're leaving something to your daughter, for example, daughter cannot be a witness. Anybody can be a witness except though the beneficiaries. Now, if it is that a beneficiary signs as a witness, then whatever that beneficiary would have gotten under the will, they will not be able to get that asset. So for example, again, let's say you leave your dwelling house to your daughter, and then this said daughter signs as a witness to your will. The daughter will not get the dwelling house as you would have indicated in your will. An executor, as I said, anybody except the beneficiaries can witness, so an executor can also witness the will. Now, let me explain who is an executor. So one of the things that you would put in the will is who will be your executor. Executor can be more than one or more. Now, an executor is the person who will actually carry out the wishes that you put down on paper. They are the ones, when it comes time to probating one's will, that will sign the documents, the relevant documents that will be processed in the courts. So it is very important, and your executor can be anyone's, but it is very important that you choose somebody who is trustworthy. It is important that you choose somebody who is willing to accept that duty. That is very important. I have a few cases right now where we have to be taking additional steps to force the executor's hand because they are unwilling to have anything at all to do with the estate. All right, and you have to take extra steps now to get them out of the way so that someone else can go ahead and deal with the will. So it is very important. You need to talk whomever you're going to use as your executor. If you're not certain whether they will accept the responsibility or not, it is important that you speak with them beforehand before you appoint them as your executor in your will. And as indicated before, and you need to find somebody who is trustworthy, right? Because much control of your estate will be in their hands. And that brings me to things that you need to bear in mind when it comes to will making and probating of your estate. So I have been talking about probating, and what that simply means is the process by which a will is processed after the testator has passed. So you leave a will and you said, I leave so-and-so to X, so-and-so to Y. It's not that once you have passed and the will is read, that automatically those things will just be turned over to them. No, the will itself has to be processed in the court, either the Supreme Court here in Jamaica or the parish courts in Jamaica, right? And the process is really a lot of paperwork, and it is best carried out by an attorney. And as I indicated before, the executor is the one who will sign these paperwork to have the documents processed in the court. One of the first responsibility of an executor once a person dies, right, is to garner how much debts that person may have been in. And that's the first step. The person, and this is important because the person may leave behind, say, one property, and this one property is valued at $20 million Jamaican. But then he may have debts amounting to $30 million, right? What that means is that that person who should have inherited the property, the $20 million property, won't have anything to get, because the debts of an estate has to be cleared up before any of the gifts are disbursed. So if the person leaves behind a lot of debts, you may find a situation that the gifts, the assets that are left behind will not go to their beneficiaries, because the assets have to be sold to clear up the debts of the estate. So just because you leave something to a beneficiary, it doesn't mean that they have to get it. Another thing to bear in mind too, when it comes to will, is that we have here in Jamaica what we call testamentary freedom. It means the will gives you the freedom to say what is to happen to your estate. Now, the courts generally are very reluctant to interfere with somebody's testamentary freedom, but there are cases in which a court may interfere. So, for example, the Inheritance Act of Jamaica, it allows certain dependents of a deceased person to apply to the court for reasonable financial provision for maintenance. And it would be on the grounds that the will did not adequately provide for their maintenance. And let me give you an example of this. So the deceased person may have had, for example, a special need child, adult child, but who was really dependent on them for their maintenance. And in the will, the deceased person may say, I leave $100,000 to this child, right? But there are significant other assets that the deceased left, but to other beneficiaries. This special needs person can apply to the court, right, to have the estate adjusted so that they can get a greater benefit of the estate on the grounds that they need that for their maintenance. And whilst the deceased person was alive, this deceased person is the one that was maintaining them. This is really one of the only way that a court will interfere with a person's testamentary freedom. Another thing to note, a will is revoked by marriage, right? So I made a will today, next week I get married, it will no longer be valid. You will have to do another will, right? After you have married for it to be valid. So that is very important to note. I don't think a lot of people would actually know that. It is also good as we go along in our life to, from time to time, update our will. Of course, this is when, when we continue to gather more assets, you would want to amend your will to incorporate these assets that you would have been acquiring. You do not have to though. That's an option. Another option though is to use what is called a codicil, right? And what a codicil does is like an addition to your will, right? And it is used to make amendments to your actual will without having to do a brand new one. So that's also an option. Also, in our will, as attorneys, we tend to put in what is called a residuary clause. What this clause really says is that if it is, well, whatever I did not specifically mention in my will, then that clause can indicate that whatever it is, it can go to my son, for example. So you had mentioned in your will, you mentioned your property, you mentioned your bank accounts, but you did not mention a motor vehicle, right? Maybe at the time you didn't have that motor vehicle. The residuary clause, right, will indicate that whatever you don't specifically mention, you can say in that it can go to your son. So that will take care of anything that you did not specifically mention. So because of this clause, there are times too when you may not have to amend your will, because this clause will catch this new vehicle that you get, and it would have gone to the person who you had named in it anyway. So you won't necessarily need to do a new will. Now, why is it important to plan your estate and make a will? When you plan your estate and when you make your will, you get to say what will happen to your assets, and you get to say who the beneficiaries would be of these assets. If it is that you do not make a will or do any other sort of estate planning and you die, then it is the laws that will indicate what will happen to your estate. So it is very important. You either take the chance to say what will happen to them, or you leave it up to the laws now to decide who is to get your assets. And I myself, I don't know about you, but I would love to be the one to say what will happen to my hardworking assets rather than to just leave it up to what the legislation says. All right, so I'll briefly touch on what will happen if you don't leave a will or don't plan your estate. The relevant legislation indicates who your beneficiaries would be. Your spouse, if you have left behind a spouse, children, and parents, siblings, it goes down in the line, right? Now, I've seen situations, and this is just to highlight how important it is to do some sort of estate planning. I've seen situations where husband and wife have not even spoken in years, have not seen each other in years, are basically estranged. But they did not get a divorce. No, husband died, no divorce. Who is his main beneficiary? His wife who he doesn't even talk to anymore, right? Whereas there may have been other persons who was in his life that he would have loved to get his assets, but because he did not put that in writing, then it is the laws that will indicate who will get what, right? Now, there are certain, so we've spoken about the ways in which we can plan for our estate. We spoke about the 4 ways, and we dealt quite a bit in making of wills. Michelle, is there any questions? Are there any questions so far? You're on mute.
I'm glad you asked. There are a few questions that came in. So
Yes.
I was about to ask you for a break. Okay. So one of the questions that was asked is, will a will drafted in the States, the US, be deemed valid under Jamaican law as it relates to any property that the testator has in Jamaica?
Yes. Once it satisfies the formalities of a will here, I do not know what the formalities of a will is in the United States, but once it satisfies the formalities of a will here, it will apply. So once it is signed by the testator, once it is witnessed by two persons, then yes, it will be valid here. And sometimes in those scenarios, a will made over the US may have properties in the US or assets in the US and have assets here. What will happen is that it can first be probated in the United States, and then it can be sent here to go through a process in the courts that we call resealing of a grant in order to facilitate the transfer of the assets. So once it has the formalities that we require here, then yes, it will have an effect here.
Okay, thank you. Another question I have is, can the executor also be a beneficiary of the will?
Yes, they can. Executor can be a beneficiary of the will. And oftentimes they are, because as I said, the executor is going to should be somebody that you trust, who is willing to carry on the duties. And oftentimes this may be a family member and a family member that you're leaving assets to. So it happens oftentimes that an executor is also a beneficiary. But if that is the case, importantly, if the executor is a beneficiary, they cannot witness the will. Because as I said before, a beneficiary cannot witness the will. And an executor can, but not if he's also a beneficiary.
Person wanted to know if you could go over what to do when someone dies interstate.
All right. So when somebody dies interstate, one has to do what is called administration of the estate. So it's not, when it speaks to probate, you're talking about a will. When it talks about administration, then you're really referring to where a person does not leave a will, right? And this is an application that also is made through the courts, right? One of the beneficiaries can become the administrator once the other beneficiaries consent. So for example, the person died, did not leave a will, left behind 4 children, right? 4 children only. And they now want to have the 4 children will be the beneficiaries. There's no spouse, so the 4 children will be the equal beneficiaries under our laws here. So they want to have the property transferred to their names. One of the 4 can elect to drive the process and making the application to the courts. All that needs to happen is that the other 3 have either consented to the application in writing, or if an attorney is involved, then the attorney will ensure that they have notice of the one sibling who will be administering on the estate. When you administer on this estate, it doesn't mean that you become the owner. It is just to facilitate the processing of the estate so that at the very end of it, the beneficiaries, according to the law, would obtain the ownership of the assets. It is a similar process to probate in terms of the paperwork that you file. It is different though in terms of the outcome, because the beneficiaries are who the law says are the beneficiaries, as opposed to with a will, it is who you put on paper. Those will be the beneficiaries. Yes.
Okay, thank you for that. Another question I got was, what if a father died and leave a child with special needs?
With that, if they left a will, if they leave a will, well, I get that perhaps they're asking about if they do not leave a will.
Yeah, I think that's what they're asking.
Well, whomever, because if it's a child with special needs, then they may need someone who puts themselves in a guardianship position would have to do the administration of the estate with the special needs person being the beneficiary of the estate, right? But obviously, if the person needs guardianship, then the guardian ultimately will be the one who will manage the assets for the special needs person.
Okay, because she said,
the guardian can't just get up and say I'm the guardian. They actually have to apply to the court to obtain guardianship.
okay, because she said my child was 3 years old when her father died, and she leaves Jamaica at the age of 7 years old. So that's a follow-up to the question I asked prior about.
Her child was 3
years old when her father died. And she left Jamaica at the age of 7.
Oh, well, somebody really should administer on the, well, what that person needs to do, you know, is find out whether anybody has ever administered on her father's estate, right? Because we don't know that may be completed. And so this person who's writing would be the mother of the special needs child?
Yes, she said my child.
Okay. And well, she can be in a position to administer on the estate of the father, but she would need to, because it involves a child. So when it comes to administration, once a child is a minor is involved, a minor is a beneficiary of the deceased person, then the administrator general is the body that will actually manage the administration of the estate. So it's a case in which she would need to contact the administrator general to inform them about the situation, and then they will take it from there. If a minor is not involved, then an attorney can do the administration. But once a minor, then it's the administrator general that deals with the administration of the estate.
Okay, thank you for that. Another question was asked, if the executor signed, so the executor will forfeit the items given to the executor as a beneficiary? That was the question. Yes. Okay, and they also wanted to know.
They're asking if the beneficiary witnesses
will forfeit the items given to the executor as a beneficiary, based on what you said.
Yes. So they would not get, the will still be valid because there may be other clauses in the will dealing with other assets. But as it relates to whatever that beneficiary was to get, then that gift will be forfeited, yes.
Okay, and another question was, if the executor signs the will, right? I guess they're asking if the executor signs the will, if that's okay.
The executor can,
and another
one is not also a beneficiary.
Okay, it's a lot of questions, so I'm going through. I hope you don't mind.
I know it is that. I know that the topic leads
a hot
a lot
topic. Okay,
yes,
so
go ahead.
The next question is, what can be done if you are an only child and you have lived on the property, but your parent doesn't leave anything for you in the will?
Well, that's what I had indicated earlier, that there's a petition that you can make to the court, right? For the court to go behind what the will provided, right? To find that assets that were left, that you, being a person who needs some sort of maintenance from the estate, that you can apply to the court and ask the court to see you as such a person, so that you can in fact benefit from the estate.
Okay. Another question, it's a lot. Is there a way to find out if a will was ever entered in Jamaica following a death of a family member?
No, because once the will is signed and witnessed, it does not need to go anywhere else. So there's nowhere that you need to lodge that will. So there's no sort of inventory that you can, government inventory that you could go to make any sort of search, unfortunately. Once it is signed, and the ink is dried, it is valid, and it does not, you need not do anything else with it. So that would be impossible to find. What some persons sometimes do, because some persons, they make their will, they don't really tell anybody, right? But after they pass, a beneficiary may know that, yes, they did make a will, they believe they did, and maybe they know which lawyer they used to use while they were alive. So they will go to the lawyer and ask him to do a search in their vaults to see if they find any will for that person, because I've had to do those searches before. So no, there's no large government inventory though that you can go to and search for a will.
Okay, so okay, another question asked is a will public information that anyone can request a copy of?
It is not, and even while it is being, so say the person, the testator dies, and the will is being probated in the courts, it will not be public information, and only if you are a possible beneficiary of the estate that you could actually get sight of it, right? But if the will doesn't mention you as a beneficiary at all, then it is very likely that you would not get sight of seeing.
Okay, another question is asked was, what would happen where there is a generic will, but the testator's intent is not clear?
Well, that is something that the courts will have to, it is a matter that may reach before a judge, right? And based on the circumstances of whatever anybody who's alive is able to give, then the court will make a determination as to the intention of the testator when they put down whatever they did in writing. So it will become a legal investigation. And there are means and ways, there are legal procedures that a court will use to determine what they believe was the intent of the testator.
Okay, thank you for that. Another question from the follow-up from the lady with the daughter. She said,
Yes.
I did and was told my daughter was told she would be contacted. This is about 2 years ago. And she was told it would be dispersed soon, but she never heard about it again. So how can they follow?
Perhaps she could, speak to an attorney to intervene, but ultimately it's really the administrator general that has to deal with the estate. But she could, if it is that she's not getting anywhere with them, she could have an attorney intervene to speak with them or to write to them to get some firm answers as to what is happening with the matter.
Okay. And another one is, how would a possible, I guess, beneficiary get a copy of, I guess, a will, if you're the beneficiary?
Well, it depends. I mean, if the will is with an attorney, then they can simply write to the attorney and they obtain a copy of it. If the executor has the will, then the original will, then you can ask him for a copy, or whomever it is that have the will, you can ask for a copy. If it is that it's not forthcoming, then you may need to get an attorney to intervene for you as well. Meet. mute.
Sorry. Okay, so those are all the questions that I got so far. And I really appreciate you answering them. Is there anything you want to wrap up with or anything?
I think that is about it, just to again indicate that it is important for us to think carefully and hard at what will happen to our assets when we pass. I know that some persons don't really care, you know what I said, they can't bring it with them, so they don't really care what happens to it after. But if it is that you do care, then it is important that you look into the different areas in which you can actually plan your estate. Yes, thank you very much.
Yeah, they were asking for your contact information.
Okay, I'm with the law firm of Murray & Chuck, as you indicated earlier. Our numbers are 876-954-5993 or 876-954-4016. The cell number is 876-775-4649.
Okay, do you have an email?
I was just about to say that, right? So you can email queries as well. So the email address is Murray and Tucker, MURRAYAND, so spell out and, Tucker, TUCKER @gmail.com.
Okay, I have one more question before you go and before I ask you to repeat, you know, the contact information. If a relative dies and leave part of their estate for you and the executor said they cannot find the will, what can be done about this?
If there's no will, then you can't probate, and it would have to go to administration. If there's a copy of the will, an application, if it's a photocopy of the will, because when you probate, it has to be the original. You probate the original will. But if it is that, suppose someone happen to have a photocopy of the will, right? There's a way you can apply to the court for their permission to probate that photocopy. You have to satisfy certain conditions, of course. But if no will at all can be found, remember I said earlier, the will has to be in writing. So you would have to proceed as if there is not any will, and the estate would have to be administered on.
Okay, all right. Could you provide your information again? They're asking for it.
No problem. All right, so the telephone numbers for us at Murray & Chuck is 95876.
Hold on, 955. Okay, 954.
4016.
4016.
Yes, remember 876 before that.
Yeah, I put that. And the other number?
876 again, 954-5993. And also the cell number.
Okay.
The cell number now is 876-775.
Hold on. 876-775.
Yes.
Yeah.
4649.
4649.
Yes. And do you want me to repeat the email address?
Yes, the email.
Okay. Email address is Murray, MURRAY.
Okay.
The word and, AND.
Yeah.
Tucker, TUCKER @gmail.com.
Gmail.com. Okay, so let me repeat it. Okay, what were you saying?
I'm one of the attorneys here, but if it is that you want to address me specifically, then you can just, in the subject line, can put it to my attention, Karisha Mckenzie.
Okay, one more question came in. Sorry, we have a little bit of time. Okay, my mom died, leave a piece of land in Jamaica. She has 3 daughters. My uncle took the land, sold it. What can we do?
Well, that can only be, I don't know how the uncle would have sold it. He would not be a beneficiary. The 3 children would be the beneficiary. A lot of things could have happened. I don't know if there's a title. And if there's a title, supposedly it could have been that the uncle's name was on the title. I do not know. But if it is that the uncle's name was not on the title, right? And he was never gifted the property in the lifetime of their mother, then what he would have done is fraudulent, basically.
Okay.
Yeah.
Okay. All right. All right. Thank you so much, Karisha. So just a follow up, because people have been asking on the different platforms. The telephone number is 876-954-4016 or 876-954-5993 or 876-775-4649. And the email address is Murray, MURRAY, and AND Tucker, TUCKER, @gmail.com. So you could reach out to her. One more question before we go.
That's fine. I know, I'm not surprised.
And anybody,
Yes.
if you have additional questions, I put her information there. So you could definitely send her a message, call or send a text. So the last question is, how does common law wife or husband will benefit from a will if you're common law?
From a will?
Yeah.
Whatever you put in your will, you know, will be carried out. So you can leave your assets to anybody at all. There's no, and that's the benefit of a will. If you can leave it to a stranger if you want, you know, so there's no bar against you having to leave it to a wife or to children. You can leave it to anybody. If you don't leave a will though, right? And you are a common law wife or husband, what our law says is that the matrimonial home, so whichever home you are living in as man and wife, right? The surviving spouse automatically will inherit 50% share of that matrimonial property.
Okay.
Yes.
All right. Thank you so much. I really appreciate you providing all this information. And just for everyone to know, Karisha Mckenzie is located in Jamaica, and I provided her contact information. You can contact her, and we're gonna post this information, this video on our YouTube channel for you to view it at any time. And tune in next month when we'll provide another informative session to provide information to help all those Jamaicans here and abroad. Thank you so much, and everyone have a lovely afternoon.
Thank you. Have a good evening, everybody, as well. All right, take care.